4, 3, 2, 1.
Hi, you're watching BloombergQuint, and today we're raising the question about the Z Invesco battle. Has it gone from being a dispute over governance to now some form of takeover or control fight? Well, let me bring you up to speed with the details of the case before I start this discussion and welcome my guests, because many of you may not be fully aware of every nuance. So bear with me as I lay out to you the events of the last couple of months. Now, in a year of active institutional investors, the first round of Invesco versus Z Entertainment seemed to be just that, institutional activism. The foreign fund, that's Invesco, together with an affiliate, which is OFI, owns about 17.88% in Z. It sought an extraordinary general meeting, or an EGM, to oust Puneet Goenka. Puneet Goenka is the managing director and CEO of Z Entertainment. Invesco also wanted to oust 2 other directors, who eventually, a couple of days later, stepped down. Through that EGM, Invesco also wants to appoint 6 new independent directors to the media company's board. It has cited poor financial performance, stock performance, and governance concerns as reasons for requisitioning this EGM and revamping the Z board. The Z board, which is the current board, has rejected Invesco's EGM requisition, saying it is illegal and invalid. It is not compliant with company law, takeover regulations, competition law, and many other provisions in law, says the Z board. That matter is now in court. In the middle of all of this, the Z board also approved a merger proposal with Sony India that's currently under negotiation. If that merger goes through, then almost all of Z's shareholders get reduced to half their current shareholding. That's an approximation. But what started as a shareholder activism battle has now seemingly gotten contorted into a takeover battle of sorts. Recent revelations show that earlier this year, Invesco approached Puneet Goenka with a proposal to merge Z with media entities of Reliance Industries. That's Mukesh Ambani's owned Reliance Industries. Now, Goenka says he found that that proposal brought to him by Invesco overvalued the Reliance entities and was short on details. Hence, he did not take it to the board of Z Entertainment. Invesco says it was only facilitating negotiations between Reliance Industries media entities and Goenka. Reliance says the deal fell apart because Invesco and Goenka did not see eye to eye on one critical condition, which is Goenka's proposal to increase promoter stake by subscribing to preferential warrants. This war of words has played out over the course of the last 48 hours. Now, in all of this, it is important to know that Puneet Goenka is the son of Subhash Chandra, the founder and current promoter of Z Entertainment and the Z Group, except that the promoter stake has now dwindled to 3.99%. So 96.01% of this company is owned by public shareholders, both institutional, which is the majority, and then a small chunk of it with retail shareholders. These events have thrown up several legal and governance questions. And to answer them, I'm joined by Umakanth Varottil, Associate Professor at the Faculty of Law, the National University of Singapore, and Murali Neelakantan, Principal Lawyer at Amicus. Uma and Murali, thank you very much for joining us on BloombergQuint and for peacefully sitting through my very long introduction. Okay, my very first question is, what do you make of the turn that this battle has taken, if I can use that term loosely, from what seemed to be a shareholder dispute with the board or a governance dispute or shareholder activism to what may now look like some sort of control battle? Uma?
Yeah, thanks. As you rightly said, Menaka, this started off as being a typical shareholder activism type dispute where the Invesco was trying to bring about governance changes within the organization, but they came up with somewhat of a recalcitrant promoter. And they have now upped the ante and moved things forward and tried to change the board itself. So it seems to me what looks to be a US-style proxy war fought in Indian conditions, and which is a very new kind of arrangement, right? Because we don't see these kind of proxy wars in the Indian context before. So I probably would say it's a little premature to call it a full-blown takeover. Of course, there are merger transactions on the way. There has been the Reliance Entertainment deal. Now there is a Sony deal. But it seems to me that it seems to be more in the nature of a proxy war, where you have a very strong investor up against a promoter who doesn't want to cede control of the company and wants to remain entrenched in the company. So it's a bit of a hybrid situation that we have, and may even be a novel kind of a situation in the Indian context.
And making it more novel, Uma and Murali, is the fact that the promoter actually does not have any control over the company, right? Because with a 3.99% stake, the promoter is a much smaller shareholder than many other groups, including Invesco, who together with OFI, as I pointed out, has 17.88%. Murali, are you seeing this as a proxy war for control, or are you seeing this simply as an institutional shareholder seeking to be active and finding the best strategic answer to Z's future?
I see it as, after a long time, institutional investors thinking more about the company than about short-term share price. Although in this case, clearly people have lost money. But neither Uma nor I think, will know what's in the minds of these investors and whether they intend to seize control or not. We can only say after the event whether there was a change of control. In this case, who is currently in control of Z is a question to ask. If you say it's only shareholding, then frankly, that is to be tested whether the Goenkas and Subhash Chandra really control the board or not.
But how can he, Murali? He has only 3.99%. Invesco is 17.88%. Even it can't control the board.
Well, that's fantastic. If we reach that conclusion, then there is no change of control.
Okay. So you're saying this is still in the realm of active institutional shareholder, which is also a sort of almost new phenomenon in India. Is that correct?
It is. And I'm saying this only because we have to establish whether shareholding below the 26% threshold can give control. Now, if you accept that proposition, then one can argue that Goenka and Subhash Chandra have control, or it's possible to argue that. In the same way as it is possible for the Goenkas to argue that Invesco intends to seize control. So the question of control becomes relevant under the 26% threshold. Do either of them have the ability to pack the board? The allegation Z is making against Invesco is that Invesco is trying to pack the board, seize control of the board and management, and therefore Takeover Code, Competition Act, all of this comes into effect. Now, by that proposition, we must test whether Z is controlled by Subhash Chandra and the Goenkas and their entities. So we have to apply that test to both. And I don't know the answer to the first question. If the answer to the first question is, are the Goenkas in control of the board? Is yes, then it is possible to argue that with less than 26%, Invesco can, I'm not saying it does, can seize control of the board.
Okay. We'll come back and examine that issue because that is one of the reasons why the board rejected Invesco's EGM requisition. But before that, I do want to talk about some of the more recent issues. And one of the questions that does come up in my mind, since you said this is right now in the realm of investor activism or institutional investor activism, is it's not common in India to see institutional investors go ahead and negotiate a deal with the MD and CEO of a company who has only 3.99% and another interested party, which in this case is Reliance Industries. So what do you make of the fact that Invesco, as the Z board points out, had no authority to do this, but yet was trying to see if a fit could be found?
Again, I think this is certainly a novel scenario, and there's a little bit of a difference in the legalities and the way it was carried out. So legally, as Z suggests, it's absolutely the case that Invesco did not have any authority to undertake the transaction. They are only a shareholder of the company and cannot bind the company to any such transaction. So maybe they would have initiated a transaction or facilitated the transaction. But it seems to me that that was only the initial step, because ultimately the transaction could not have been carried out or implemented without the approval of the board. So nothing prevents a shareholder from initiating, facilitating, and it seems to be on the facts that at that point of time, at least Mr. Goenka was willing to talk to the counterparty. It wasn't as if there was a rift in the relationship as there is now. So nothing prevents a shareholder from initiating or facilitating a transaction, so long as everybody is clear, and that is the case with the law, that the final approval of the transaction has to come from the board. So to that extent, I don't think it's unusual in Indian circumstances, but I don't think there's any breach of any law or anything odd in the legalities of the transaction.
Uma, a couple of quick follow-up questions on this, and then I'll get Murali's view in case it's counter. And that is that, should Invesco have approached the board instead of Puneet Goenka? I mean, why would they go to Puneet Goenka? Yes, he's MD and CEO and therefore management, but he has only 3.99%. So are they looking at Goenka as management? Are they looking at Goenka as promoter family? Should they have taken this proposal maybe to the board? Would that have been a better thing to do from a governance point of view? Because like you pointed out, there is no law or regulation being violated in an institutional investor trying to see if there is a strategic fit with some other party.
So I think that on hindsight, there could be possibilities that may have been overlooked on either side. So firstly, the logical thing to have been done would be for Invesco to have approached the board, which is what is done, maybe the chairman of the board, because this is a transaction which involves the board as a whole. But having said that, I don't think there's anything absolutely odd about approaching Mr. Goenka, because he is, after all, the managing director of the company. So maybe it's the first step is to approach the managing director of the company. But there's a second step to that. And Invesco has no obligation, maybe from a governance perspective, yes, no obligation to the board. But secondly, the question is whether Mr. Goenka should have involved the board or not. And that's a more difficult question, because I would place the onus on the managing director of the company to have raised this with the board, because this is a significant transaction. Even if it did not fructify, even if it was not taken up beyond a particular stage, a merger is a life-changing transaction for the company. And however preliminary that stage of discussions were perhaps it would have been a case for the managing director of the company to have informed the board. So yes, from an Invesco perspective, there are issues from a governance perspective, but I think managing director certainly would carry that onus to inform the board.
Okay, but Uma, let me just clarify. These disclosure requirements are somewhat open-ended on the SEBI regulations front, right? So it does leave it up to, let's say, the managing director or the CEO or the board, to determine whether there was a disclosure requirement violation by Goenka not taking this to the board, or eventually if he had taken it to the board, whether the board reveals it to the public. Because from what I understand, unless you're fairly confident of a deal becoming a reality, you don't necessarily need to disclose it. Yes. So there's no law or regulation violated here. It's what, as you pointed out, it's a more of a governance or perception thing.
Yeah, except for one part. Yes, you're right that the SEBI regulations are not explicit on this. But being a fiduciary as a director of the company, a director has an obligation under general company law to act in a transparent fashion. So that transparency may be something that's called into question. Again, it's not explicit in SEBI Regulations Companies Act. It's more implicit in the whole gamut of directors' duties, which Mr. Goenka will carry as a director of the company.
Okay, fair enough. Murali, your view on this?
I think to say that this is unusual in India for shareholders to bring deals to companies, I don't agree. You look at the plethora of PE firms who are doing deals, there's a lot of matchmaking happening. They look at their portfolios and think, how can we get these two companies to play with each other? How can we merge them?
In the listed space?
I'm saying I have seen conversations happen on this for many years now. Whether they actually go out and announce that they have investments in two different companies that are going to merge or not, or do transactions with each other, you can test it on the CCI website, where you had PE companies saying, here is a company which we've already invested in, same space. We have another company that we're going to invest in. And then many years later, you see them doing stuff together. So I think matchmaking has happened in the past. There is nothing that prevents shareholders, especially institutional shareholders, from offering suggestions and trying to do something for these companies. I think Invesco is right in going to the managing director, because it doesn't need to go to the board. It's up to the managing director to think this is an opportunity for the company. And very old company law from more than 100 years ago says that if any director gets an opportunity which benefits the company, then he should disclose it to the board, and the board should discuss it. More so in case of such a substantial transaction like Umakanth mentioned, a merger. which changes the life of a company. Definitely, there is a duty on a director to take it to the board and then let the board decide whether it wants to go forward or not. It's very different from saying, I want to acquire a brand, I want to acquire, a manufacturing unit somewhere, acquire any of these things, perhaps not substantial transactions. Then you don't take it to the board until you think that the transaction has legs, it's likely to succeed. We've got some interest between the parties, and then you take it to the board. So on one hand, it's not necessary to take every transaction to the board, but I think an offer of a merger is a substantial transaction, should have been taken to the board.
Okay, so both of you agree that in this case, at least, whilst Invesco was right to maybe seek opportunities of this nature and approach Puneet Goenka ought to have informed the board. Now, why this gets sort of emphasized is because of what we are hearing from the various sides. We don't know the full details of the negotiations that went on in February and March between the Reliance representatives, the Invesco representatives, and Goenka. But what we do seem to know is that Goenka says the deal overvalued the Reliance entities. There were not enough details with regards to the deal. And he also, in his letter, says that there was some disagreement with regards to how to increase promoter stake. The Reliance statement yesterday says very clearly that Invesco and Goenka did not agree on the method of increasing promoter stake. That Goenka, I think, seemed to want to subscribe to some sort of preferential warrants, and that Invesco thought that if the promoter wants to increase its stake, it should buy from the open market. Now, that's when it gets even more interesting. That did Puneet Goenka, because he didn't think the deal did his family what he wanted it to do, not take it to the board, and therefore, makes this situation somewhat worse, Murali?
And that's exactly why I said what I did, which is that the information that we have now surrounding how this deal didn't get done suggests that it's definitely one that should have been taken to the board to say, here are the issues. We think there is a valuation issue, but there's also these other things that we're discussing, which will hurt me and my family as promoters. That's the level that I would expect any director in any company, listed company, to have as a fiduciary duty.
Okay, Uma, you think that in this case, Puneet Goenka played more promoter than managing director and CEO? And let me tack on a second question to that to move this forward, which is that having tried to strike a deal and having failed thereafter, do Invesco's subsequent actions, which we've characterized as a governance dispute and shareholder activism, do they get colored by the rancor of, hey, we wanted this deal to go through, but it fell apart because Puneet Goenka was not agreeable?
Yeah. So to answer your first question, yes, in a scenario like this, who decides whether the transaction is fair to the company or not? And when I say fair to the company, here there's a question that you raised. Is it are we talking about fairness to the company, or are we talking about fairness to the current promoter of the company? And that is really the big question. So the issue that has arisen is the rejection by the managing director of the company may arguably have been largely colored by the fact that it was not a good deal from a promoter's perspective, not necessarily from a company's perspective. So who determines whether the transaction is fair to the company or not? It should be the board. And quite often the board, after obtaining advice from, let's say, financial advisors who are experts in this, but none of that happened in this case. One gentleman decided whether the transaction was fair or not, and that was the basis on which that entire transaction fell through. And so there are some real concerns because the governance mechanism would be broader, and that is not something that has been taken into account. Which naturally leads to the other side of the coin, which is, are we talking about a disgruntled investor whose proposal failed that led to a rift between the parties that has led to the subsequent actions, such as bringing the EGM to replace the board? I think that certainly that seems to be the case. If you line up all the events, it seems like the relationship between the parties, I wouldn't say was perfect, but was at least okay until that transaction failed. And it is only thereafter that the investor started acting more aggressively. But does that matter? Perhaps not in the overall scheme of things, because nowhere is it required that the party has to come with clean hands. You can ask for an EGM. That's a right available to a shareholder. And in these kind of cases, there is always going to be disputes and disagreements between the parties, and that's just the nature of these kind of governance disputes. So it seems to me that yes, there is a question of being a disgruntled investor, but I don't think it will matter in the overall litigation that takes place, because each party has the ability to exercise their rights.
But Uma, if you're an institutional shareholder with 17.88%, this big US fund, and you're fighting a governance battle, as you put it, with the Z board and the Z promoter, and you're pointing out all the flaws in the way they operate, then shouldn't you have made the disclosure of a failed deal before you sought an EGM, saying, look, whatever your justification for the deal was, that we thought this was a great deal, the management didn't even take it to the board, we think this is a governance failure, and therefore this is one of the many reasons for why we think we should requisition an EGM. Let's not forget, till Puneet Goenka's letter made transparent the fact that there was a deal in the making in February, March, there was no official disclosure. There were lots of rumors in the market, but there was no official disclosure.
Yeah, you're absolutely right, Menaka, but I think the question here is who has the obligation to disclose? And here it is a company that has the obligation to disclose. Invesco has no obligation under law to disclose. In fact, Invesco may be jumping the gun if they go ahead and make a disclosure that the company was in fact supposed to disclose. So maybe if they had done so, they could have drawn a lot of flack from the company, and perhaps they have been silent about it, and rightly so, until this dispute occurred. So I'm not sure if there was anything on Invesco's part, either in law or in governance, for them to go out and make a statement that this deal was there, the deal fell through.
Okay, Murali, a quick last sort of response on this part of the debate, which is that who comes off looking worse? Puneet Goenka for having, rejected a deal for reasons that might be germane to promoter stake, even though his family owns only 3.99%. So it isn't even he has the controlling stake. He knows he can vote down the deal if it ever came to a shareholder vote. And so he killed it right at a preliminary stage, not waiting for it to get to an advanced stage. So does Puneet Goenka come off looking not good in this process? Or does Invesco also come off looking not good in this process because they didn't make some of these disclosures? They didn't come to the table with clean hands?
This is not a Miss Universe contest, right? Who comes out looking good? So let's not go down that path. I think in this case... But
this is a governance battle, Murali. I mean, you can't say I'm fighting a governance battle and then say, oh, but these things don't apply to me. I'm just asking. I'm neither Invesco nor Puneet Goenka.
No, I'm agreeing with Umakanth to say that the law doesn't require Invesco to make disclosures.
Okay.
Actually, the law prevents Invesco from making disclosures because the obligation on disclosures, the timing of it is all with the company. So I think in public perception, you can start off once again with East India Company Part 3, 4, 5 or whatever, and blame Invesco for all of this. And that's all the PR play. I don't think either of us can make much of a comment on the PR play. But as far as the law goes, Invesco comes out looking like it did what it could for the benefit of Z. Whether or not this deal is good, we will find out in due course. So we don't have enough details to say whether the Z-Sony deal is good or not. But definitely, the board comes out looking very bad, and the managing director comes out looking really awful in this whole exercise. So on one side, you got the board and the directors who are responsible for compliance, responsible for management, responsible for disclosure, all of this. On the other hand, you have Invesco, which is only a shareholder. And don't forget, the shareholders don't have to be consistent. Now you're seeking Invesco to be consistent. They don't have to be consistent.
Yeah.
They have rights under the Companies Act. They have no fiduciary duties under the Companies Act. They have rights which are not tagged to a previous duty. So their right to call a requisition a meeting, their right to change at least propose members on the board, all that is not tagged to previous good behavior. So let's not mix the two up and try and weigh them on the same scale. They have different duties, they have different responsibilities, they have different rights. And in this case, Invesco can choose to, play both sides, hunt with the hounds. And
yeah, you make an excellent point about the board's role in all of this. I'll use that as my last question because I do want to talk about the rest of the public shareholders besides Invesco and besides the promoter. The board ought to have, at least at this point in time, said, we want to see both merger proposals, right?
Yeah.
Because we want to compare which one is better or not. Instead, the board seems to be fighting some proxy war on behalf of Puneet Goenka. But before we get into that, let's take a look at a previous action by the board, which is the rejection of the Invesco EGM requisition. Now, you pointed out, Murali, that they have a right to requisition an EGM. That right is provisioned for in company law, which says that if you have not less than 10% as a shareholder of voting rights, then you can requisition an EGM. We know for a fact that Invesco has 17.88%. And so Invesco has been arguing that there is no question about what we want to bring to vote in the EGM, whether you like our directors that we have proposed or not. All of that is secondary. Primary is that we have requisitioned an EGM under law that is provided for, and the board ought to have allowed for that to take place within the timelines in the company law. Instead, the board has argued that this EGM requisition notice is non-compliant with takeover regulations, Competition Act, MIB requirements, listing regulations, articles of association. So I want to examine with both of you some of these key, legal arguments. Let's start with MIB. The Z board says that the MIB guidelines say that it is obligatory on the part of a media company like Z to take prior permission from the Ministry of Information and Broadcasting before effecting any changes to the CEO and board of directors. So do you agree that the board is right in telling Invesco, hey, your EGM requisition is invalid because there's no prior permission in this case for the 6 new independent directors you want to bring on board?
No. And the behavior of other media companies and the MIB gives us clues as to how to interpret this Regulation 5.10.
Okay.
In the past, the MIB has approved appointments to the board after the board has decided to appoint people. So I give the example of Den Networks, where they had 4 people they wanted to appoint. They appointed them subject to MIB approval, in the same way as Invesco is trying to do. MIB then took its own sweet time, finally approved these appointments more than a year later. So there is one example, at least, there are many others, where appointments are made subject to MIB approval. So that, I think, is what the MIB wants. We have to look at examples where, if anybody can find them, where the MIB has issued a show cause notice for not following the process that Z is suggesting. And we have found none of those. I've looked and I haven't found any of those. So the view that we have to take is MIB only requires permission to be taken before actual appointment, not before putting lists of names on a board by a shareholder for the EGM to approve. Now, if the
sorry, Murali, I'll interrupt you there. Sorry for that. But in simple language, can you just expand on appointment? Because it can get very confusing. Does appointment happen at the time where shareholders approve? So, because often companies appoint, the board appoints a director as an additional director, takes it to shareholders for approval,
Right.
Shareholders approve it, then that person is either appointed as an independent director or whatever their real role is. So where does the appointment actually kick in? Where do you think that this cannot happen unless MIB approval has come in, but all the prior steps can happen?
So it's different for different types of appointments.
Sure.
So
In
this case, nothing stops the shareholders from resolving that the company appoints X as a director, but it doesn't have effect. So the appointment itself doesn't have effect until MIB approval comes.
Which means that the director cannot function on the board till MIB approval comes? That's what you mean?
Absolutely.
Okay.
And if that takes a year, then so be it. It takes 2 years, so be it. And we have examples in the past where it's taken more than a year. So if you look at the annual report, it will not have that person down as a director until MIB approval comes through. That person will not attend board meetings. So it's as if that person hasn't been appointed yet because the important aspect of the appointment, which is the MIB approval, hasn't come through. So that's that part of it. Now, if you take the alternate view, which is the Z view, that before you even propose a name to the board, you'll have to get MIB approval for it. One, that's not how precedent tells us companies and MIB has functioned. Secondly, it will lead to a really absurd situation where effectively the government decides a short list of people that companies should appoint on their boards. And companies no longer will make that list. You're now asking for shareholders of these companies to go to the government, seek approval before making a requisition. That sounds exceptionally absurd to me.
Okay, so you're saying that it would be a waste of government time to approve directors before shareholders have approved them, because then if those directors get defeated or the appointment gets defeated in a shareholder vote, you've got to go back to the government with a new set of directors. Let me get Uma's view on this. Uma, do you broadly agree? Because I must point out that I just went back and checked quickly in the case of Z itself, whether they have informed the MIB or subjected both the appointment and resignation of directors on their board to MIB approval. I looked at the resignation of 2 directors that happened as recently as a few weeks ago. At least in their filing with the stock exchange, there is no mention of we have taken this to the MIB. I looked at the appointment of another independent director last year in the case of Z. At least in the notice to shareholders, it does not seem to mention that we are, this is subject to MIB clearance. I mean, it does not seem to mention that MIB has already pre-cleared the person. That's what I'm trying to say. But it could be that the paperwork was done and filed and they chose not to either disclose it to the stock exchange or to the shareholders. What's your view on this one point of contempt?
Yeah. So I hold the same view as Murali has outlined, which is it seems impractical to go to the MIB beforehand. And MIB may very well not agree to go through it, because the first question they may ask is, have shareholders approved? Why should we waste our time going through this potential candidates who may or may not be approved by the shareholders? So I think in these circumstances, a conditional appointment is the way to go. Shareholders pass the resolution to appoint, but the appointment will become effective the day the approval of the MIB comes, until which time the person is not a director. The directorship takes effect only on that later date. So it would be in the nature of a conditional appointment. And we've seen these kind of conditional appointments, removals, transactions all the time where government approvals are involved. And this is how it takes place. Regarding your other question you mentioned about Z having done this previously. Yes, we are not sure of what the situation might be, except that I just wanted to point out that in resignations, it might be slightly different, because the resignation is a matter of right, because directors have the ability to step down from the company, subject to the Articles of Association. So I don't know whether it's their individual right and whether that can wait until the MIB approval has to be obtained. So I would take a slightly more lenient view towards the directors in the context of a resignation. But in other scenarios, this issue would certainly be the case.
Yeah, no, I'd agree with you. I'm not trying to be impractical. The only reason I brought it up because the Z board was emphasizing on the wording of the MIB guidelines, which says that it's obligatory on the part of the company to take prior permission from the MIB before effecting any change including a resignation. So since they were emphasizing on prior permission, I was using the words to see if whether this has to be taken that literally. But I have a quick follow-up question to you on this, Uma, and that is that there is some legal argument being made about the fact that, even if MIB approval is a sticky point in the sense that Z's board is not clear whether these 6 independent directors proposed by Invesco will get cleared by MIB or not, the counter argument that a shareholder requisitioning an EGM can make is that that's a post-EGM issue to deal with. You first hold the EGM. It's not the only thing in our EGM requisition notice. One of the other things in our EGM requisition notices is also to vote on Puneet Goenka's continuation as managing director and CEO, or his continuation as director on the board. And so therefore, Invesco, is it right in arguing that all of these concerns can be brought up after the EGM is held, not at this stage? We have more than 10%, EGM must be called.
Yes, that's absolutely the case, because Section 100 of the Companies Act gives a right to somebody who has 10% voting rights, which Invesco and its co-shareholder have. And interestingly, this is what was accepted by the NCLT in the first order it passed in this case, before it went up to NCLAT, and then there was a issue about filing rejoinder, etc. So the NCLT's answer was the section gives the right to a shareholder to requisition an EGM, and that voice to the shareholder must be given. That's part of a right given to shareholders. Everything else is incidental and need to be addressed. So you can't take away that shareholder voice by imposing obstacles around these issues. So I think I would agree with what NCLT has said there in those circumstances.
All right. The second issue that the Z board has used as grounds for invalidating the EGM requisition is that it's in violation of the takeover regulations. How do you read that, Uma? I'm not seeking to argue out the full case here, but I just wanted to pick some of the key objections to see whether their invalidation has feet or legs to stand on.
This is a very interesting question. So without necessarily determining who is on the right side or not, this is an interesting question, because the first issue that arises is, does the action by Invesco seeking an AGM to replace the board amount to a change in control of the company that triggers the takeover code and requiring mandatory offers and so on? So does this amount to a change of control? And the way I look at it, to start with, at a fundamental level, there is no change of control. Invesco is holding the same number of shares it held before. Invesco is not getting additional rights in the company through a shareholders agreement, articles of association. Everything remains the same. The only thing it has done is Invesco has exercised the rights available to it in the company. Does that amount to a change in control? The answer is no. And interestingly, what I also found quite fascinating is the number of board nominees. Maybe it was structured such to be. So interestingly, they have only nominated such people that their new nominees, I won't call them nominees because they're all independent directors as they suggest, which again is a factual question which we have to determine, but it's 6 versus 6. So even if this EGM suggested goes through, there is no change in control because the six independent directors currently in position remain. The new 6 persons also come in, and only the managing director steps down. So it seems to be a scenario where it has been cleverly thought through. But whether that's sufficient, we all know that the definition of control is pretty wide, the way SEBI has interpreted it. But I think there is a lot to say that this doesn't amount to a change in control. It's simply what in the UK they would call a shareholder action. But I must also mention very briefly, not to take up too much time, that it also depends on who these directors are. Do they have any connection with Invesco? Do they have prior relationships? So if there are, then I think there are questions raised. But if they're truly independent, not just of the company, but also of Invesco, then this is just a shareholder action and not a device to seek control over the company.
That's one of the other objections that the Z board has raised, that the explanatory statement that needs to sort of accompany the appointment of any director, which lays out who the director is, what their background is, and why their appointment to the board would be beneficial to the company, seems to be missing in this case. They've also pointed out other procedural issues, saying directors have to be, sort of selected by the NRC, which is the Nominations and Remuneration Committee. But I can't think that would apply in the case of shareholder action. It would only apply in the case of board-appointed directors. There are several other objections that the company's board has raised. Murali, I won't go through each one of them, but your broad take on the takeover regulation bit and some of the other procedural issues.
I agree with Uma on the takeover code. They have not exercised any control. They have no right yet. If several other shareholders, let's assume that 1,000 other shareholders join and approve this resolution, then are you saying that everybody who voted for it together with Invesco, that bunch of 10,000 people perhaps, are now all in control against somebody who has 3%? How do you read that? Control has to be a right that exists. Invesco doesn't have a right to appoint half the board or even one on the board. It is what 51% or majority of the shareholders agree in that meeting will happen. And they can't all now be termed to have control over the company because they voted on that one resolution for one independent director. So I think we'll have to think of control quite carefully and not in this manner. I think on the other issue of explanatory statement, the company has to produce an explanatory statement. Shareholders don't produce an explanatory statement. The Companies Act requires that the company issues notice of the meeting. The company issues an explanatory statement for the resolution. The shareholder requisitioning it doesn't produce an explanatory statement. So again, I know this sounds hyper technical, but
No, it's
It is
not
not the
hypothetical, but Murali, is it not contradictory? I mean, at the end of the day, how do we know if the 6 names proposed by Invesco are truly independent or not, as Uma pointed out? And if they're not, then they go to the very subject of control and takeover regulations, right?
No. So the explanatory statement, declaration of independence is all procedural. So the company can ask these individuals, of course, their consent needs to be taken for appointment. Of course, you need to agree terms of appointment with them. Of course, the company needs to agree and get a declaration from them that they're truly independent. But this is not a duty that's imposed on the shareholder under the Companies Act. Now, we may fight over whether that's the right law or not, but the explanatory statement comes from the company, not from the shareholders.
At what point does that happen? At the point of, it would
Notice.
have to happen before the EGM, right? Because otherwise,
Before the notice is sent.
Vote.
Before the notice is sent. So the requisition is sent by a shareholder to the company. The company then has to issue a notice.
And in that notice, the company board or the company in itself has to provide information on these directors and determine whether they are independent or not independent. Is that a determination the company does? Is that information?
It's a declaration. It's just a declaration.
So it's a declaration that the directors themselves provide, or Invesco has to provide?
Directors themselves provide. So you need consent from the directors before they're appointed. You need a declaration of independence from them. The company can send it to them and say, these are the 2 things we need, and send them terms of appointment. Are you willing to serve on these terms of appointment? So those are the 3 things the company needs to do by itself before the notice of the EGM is issued. And in the explanatory statement, we'll say all of these things. They're appointed for a period of so many years, and these are the terms of appointment. Here is a copy of the appointment letter. So all of this material will need to go along with the notice that the company needs to send. The twist in this whole exercise, as you've noticed, is does the board approve of these people? Because one of the requirements seems to be that the board will justify the appointment of these directors. Now, if the board doesn't justify it, can they say that, no, we will not propose the notice at all? I don't know the answer to that.
Uma, do you know the answer to that? I'm just trying to figure out. I know there are many other concerns that the Z board has raised. They will get argued out at the NCLT and the appellate tribunal, and I'm sure at the Supreme Court as well. But I mean, the short argument on the Invesco front is this is all post facto. First, you hold the EGM. We have more than 10%. We have the right to call an EGM. Whereas there seem to be many other concerns on whether these are truly independent directors or not.
Firstly, I agree with what Murali has said, and I've also found something which even supports that kind of approach, which is there is a company rule, company's management and administration rule, which talks about requisition meetings. There is an explicit provision that says that when shareholders are requisition a meeting, they do not need to provide an explanatory statement. And in fact, they can disclose the reasons for what they are raising at the meeting itself.
Yes.
Okay. So therefore, so in other words, maybe it's a little bit unfair. A lot of what we are saying is to say that, okay, investors have a less of an obligation. The company and the directors have a lot more obligation. So it's a bit imbalanced in this kind of a battle, but that's the nature of it. Directors are fiduciaries, companies have more obligations. And maybe this is a way to say that shareholders need to be given a voice. And the more impediments you impose, you're taking away that right of the shareholders. Maybe that's why the Companies Act is lenient towards that. And you're right that when things like nomination committee, etc., would come into the picture, those are not some things that have taken into account the point of activism of shareholders and so on. So that's a new thing where we'll have to see how activism fits into things like nomination committee. That would be something yet to determine.
There's going to be an interesting test case. Sorry, Murali, I know you want to say something, but there is now a sort of quantum leap in EGMs being requisitioned by institutional shareholders. I might point out that at Dish TV also there is a similar battle playing out. Murali, your quick thought on this.
You say it's new, but
it's not.
The idea that shareholders can requisition meetings was a fantastically new idea before 1956. And the 1956 Act actually, for the first time here and a similar legislation in the UK, allowed shareholders to requisition meetings. Before 56, shareholders couldn't requisition meetings. It was a nightmare for them to do it.
I didn't mean it was legally provided for recently. No. I meant that it's a newer phenomenon that more and more investors are seeking to assert their rights through EGM requisitions and other such mechanisms. So
no, the point I was making was we've had it for 60 years and hasn't really been exercised. It was a right that was fought for a very long time by shareholders. Having got it in 1956, I don't think shareholders have really used it very much in the last 60 odd years.
Okay, fair enough. So very quick one-line answers from both of you. We're not deciding the case here, but is it fair for me to then assume, based on the arguments you've made, Murali, that you think Invesco's case stands on strong ground for an EGM to be called?
Absolutely.
Uma, would you agree with that? That's what you think as well? Or do you think that the concerns raised by the Z board are equally sort of on strong ground?
Yeah, I think their rights to call an EGM and hold an EGM is on very strong ground. But what outcome are they going to get out of it is subject to a lot of these conditions that we spoke about. So in other words, I think they may get an EGM, get the shareholders to come and speak, to vote on it. But I suspect the actual effectiveness of the vote would be subject to a lot of these other issues that we've seen. So I don't think we're going to get a resolution at the meeting itself of this issue. It is probably going to take a longer time.
Okay, so that brings me to my final question. And that, what should public shareholders make of all of this? 96% of the company is held by the public. And even if you were to deduct the Invesco stake from it, which is roughly about 18%, we're looking at definitely over 75% shareholders trying to understand which side of this battle they stand on, what is in the best interests of the company. And here's where I also want to bring in the question of the role of the board. Uma, Murali, do you think that the board has done the work that it needs to, whether it is seeking more information on the Reliance proposal, whether it is today saying, hey, because let's remember, the conversation with Sony is still non-binding. So saying, hey, we want both proposals in front of the board to see which one is a better deal. Hey, we want to respect institutional shareholder rights and call for the EGM and then take care of the subsequent issues. Has the board done what the board needs to do as an independent board? Because this is not a promoter-run company. This is a diversified-held company. And what should public shareholders, non-Invesco, non-promoter shareholders, make of where this battle is going to head? Uma?
Yeah, thanks. So certainly the board should not take sides in this battle. The board should do what is best in the best interest of the company. So currently, it seems like, at least in the first scenario for Reliance, the board wasn't even aware of a deal. Now that the board is aware of a deal, perhaps it can also scout to see if this is the best deal or not. Hire independent valuers to determine whether this transaction is fair in the interest of the shareholders. So what the board needs to do ultimately is to see whether this is in the interest of the shareholders as a whole, not just the individual shareholders, whether the currently diluted promoter or Invesco. So I think that's really the battle. And from the other shareholders' perspective, I think the question is whether it's Invesco or whether it's the board, are they acting in the interest of the company as a whole to consider these individual shareholders, or are these two battling parties acting in their own interest or not? And I think the board should make sure that it is not only transparent, but that it is acting fairly in the interest of the company as a whole.
Okay. Murali, is it fair for me to assume that this can get resolved somewhat amicably if the board were to do an honest exercise of determining or evaluating both proposals from Reliance and from Sony, because both proposals involve Puneet Goenka continuing as the MD and CEO. So the leadership would remain the same in that sense. It's only because the Reliance proposal seems to have failed, that's my assumption, that Invesco has sought the ouster of Goenka. So if the board were to do its job, in fact, this could amicably get resolved, and they could, based on external party advice, determine which deal is better for the, all the stakeholders of Z, and then proceed with that deal.
Absolutely. I agree with Uma, and I agree with what you say. The board comes out looking bad in this because it looks like it's being controlled by the Goenkas. That is the issue here. And the only way it can redeem itself is by behaving like an independent board. And it would go a long way if they requisitioned the meeting, had this discussion, been prepared to answer shareholders' questions there on how they came to these decisions, and then dealt with the 96% or how many ever percent who are not the Goenkas, and convinced them that they're still a board that runs this company, manages this company well, and has the shareholders' interests at heart. So that, I would think, is what the board should be doing. Call the EGM, have this discussion, and present the case to the shareholders. Running away from shareholders, not calling the EGM, just looks terrible for the board.
And I think that's the note we'll end on, because I was quite surprised as well. I saw the board note from last night where they've responded to the Invesco open letter to shareholders. There's a lot of name calling in that letter. There's a little bit of justification as well in that letter. But there is no mention of the fact that, hey, if there is an interesting proposal from another party out there, then it's our job to see if that proposal is equally good or better than what Sony is offering. And that's what we are going to proceed in doing. Maybe they will make that, decision in the near next few days, but as yet the board has made no such mention whatsoever, except for the name calling that's been going on. Gentlemen, thank you for demystifying this. I was hoping we'd do it in 30 minutes. We've taken a full hour, and we know that Uma is just about to leave in about a minute or so on a vacation. So have a good one, and thank you both for your views and opinions here.
Sure.
Thank you.
Thank you.